All right, so let's take you live now to SABC News political editor Mzwandile Mbeje, who's standing by with Chief Justice Raymond Zondo. Mzwai, there's lots to talk about. Of course, take it away.
Sorry about that, Bongiwe. Yes, indeed, we are here where the Chief Justice of the Republic will be speaking to us. Remember, he is only 28 days in office, and of course, he will be overseeing this. I think his term will run for something like 2 years and a few months, because, you know, when you serve as the Constitutional Court judge, I think you cannot exceed 12 years or 70 years of age, whichever comes first. But of course, Chief Justice Zondo has been around, so he knows he's actually been acting in the position. And of course, he will then share his vision and will pose some of the questions that are quite interesting. In fact, Bongiwe, I'm going to start right with that story that you were just dealing with, because it relates to the courts. It will be very interesting to hear from the country's top judge relating to this matter. Chief Justice, welcome to the SABC, and thank you very much for granting us this exclusive interview.
Thank you very much. Thank you.
The first question, I'll just, as I've indicated, I'll ask about what has just transpired today. I think late today at court, there's a high-profile case that is happening, that of Senzo Meyiwa. So we saw one of the advocates of the lawyers being arrested immediately after the conclusion of the case. And I think people felt very differently, not that they don't want the law to be followed, but given that this case has been there for long and the optics of it, I don't think people understood perfectly. So what's your view?
Well, firstly, it's something that I wasn't aware of, and if it happened today, I was in meetings for most of the day, so I'm not aware of exactly what happened. So I wouldn't be able to comment much. But of course, the police will say if they have grounds to effect an arrest, it's their job to effect an arrest. And if the complaint is about how it was done, that might be a different issue altogether. But I don't know the facts. I don't know anything about it since it's something that happened today.
Okay, maybe.
Yeah.
I'm not going to probe any further.
Yes, I'm hearing about it for the first time.
Okay,
yeah.
No, that's fine.
Yeah.
I'm sure as time goes on, so you'll be appraised of it.
Yeah.
But let's come to perhaps the crux of what we hear for Chief Justice. Did you think 2 months ago, will you be doing an interview of this nature?
Well, 2 months ago would have been between the interviews and the announcement of my appointment. Well, during that period, I knew that the president had been given 4 names from which he was going to choose the Chief Justice. I knew that the JSC had made its recommendation. I knew that the president was not bound by its recommendation. So I remained hopeful that I would be appointed. But I was quite clear in my own mind that whoever was appointed by the president would get my support. And to that extent, I had given a call to my sister, Justice Maya, after the announcement by the JSC that had recommended her. I gave her a call and said to her, if she was appointed, she should know that I would give her my full support, which she accepted. So I was hopeful, but I accepted that somebody else could be appointed, and if somebody else was appointed, I would give them my full support.
Well, you're now the chair of the JSC. Perhaps I may just check your views. Do you think it overstepped its mark or its mandate, the JSC, in recommending instead of just perhaps doing the interviews and presenting to the president?
Well, let me put it this way. I think the JSC, through its spokesperson at the time, has expressed the views that they have expressed in that regard. I think what is important is that the JSC seems to accept that there was room for improvement on how the interviews had been done. And I believe that the way the JSC conducted interviews subsequently was an improvement. And I think that, generally speaking, the public appears to have accepted that the interviews, the recent interviews, were fine.
Well, I know I'm speaking to the judge. I see you avoiding my question, and I think you are putting it in a manner. But perhaps if we're just putting it short.
Yeah.
So you do believe they perhaps overstepped their mandate?
Well, I don't want to pronounce on that because it might be something that might still arise. But I want to simply say that I have no doubt that the interviews that will be done in the future will be done with clear determination to make sure that the JSC does what it is supposed to do. It will reflect, I'm sure it has reflected, it may have reflected on how they were done, because the spokesperson of the JSC at the time was asked these questions in interviews, and he dealt with it, and I think he was reflecting how the JSC at the time saw the matter.
I think there are some people who feel maybe the nature and the composition of the JSC is not perhaps conducive for this type of appointments. I think you saw some of the court challenges to some of the members of the JSC. So what's your view?
Well, I would have liked a differently constituted JSC. Yeah. But one has got to acknowledge that it's not what one person likes. You know, there are various interest groups that need to be taken into account. And we must also remember that the composition of the JSC as it is would have been something that was debated quite at length before it went into the Constitution, and that there would have been reasons why it was thought it should be constituted the way it is constituted. Obviously, there would be different views, and I certainly would have preferred a differently constituted JSC. But what we have to also remember is that for many years, the JSC is not a body that was established yesterday. Yeah. For many years, this JSC constituted as it is, leave out personalities, constituted as it is, consisting of members of parliament and some judges being fewer in number than politicians and members of parliament. For many years, it operated in a way that didn't cause people to be very concerned. I mean, it has been operating from 94, 95, 94, and it was always constituted in this way. Yeah. And it worked quite well. So it is important that we remember that when we look at what the challenges are, because it may well be that the challenges are not so much about the different bodies or constituencies or groups that are represented, but it may well be that the difficulties arise from personalities, and maybe the difficulties arise from an understanding of what the role of the JSC is. But also, I know that when people raise the issue of the constitution or composition of the JSC, they complain about the presence of politicians. Now, of course, we can have debates about whether there should be changes in the composition of the JSC or not. But, I think politicians, like to be represented in the JSC. And I don't see them easily saying we'll pass an amendment to the Constitution that kicks us out of the JSC.
Okay. You said you'd prefer a slightly differently constituted JSC. In a nutshell. So would you reduce the number of politicians? Would you increase judges?
Yes, I would increase judges. I would reduce the number of politicians.
So will this be in line with what you said, for example, during your interviews, to say you would prefer a completely independent judiciary?
No. That's a separate issue.
Okay.
But in terms of the JSC, I would prefer to have more judges than politicians. But I wouldn't mind if there were some politicians. But as I say, it's in the Constitution. Amending the Constitution is very difficult in the first place. And if you are going to ask that politicians pass a constitutional amendment to exclude them from the JSC, I think the chances are very slim that you will succeed. So it may well be that certainly I'm not saying that we should not debate the pros and cons. We should, but I'm saying that there is that reality. And we ought also to try and see how we can make this JSC work. I can say that on the two occasions when I have chaired the JSC, in October last year and in February this year, I have found that there is a lot of cooperation. There is a lot of commitment on the part of everybody to doing the right thing. I'm very confident. I'm very hopeful that going forward, the JSC is going to be doing its job very well.
Well, you will be chairing the JSC, so it should be easier to monitor and perhaps do a follow-up interview to say, is it
working well?
Yes.
Yeah.
Moving on to something else. Chief Justice, I think we lay people end up using this phrase I'm going to use now. Justice delayed is justice denied. So the context of my statement is that it would appear that the courts are the ones who delay the justice. There's huge backlog. As you come into office, what are you going to do about this?
Well, you raise a very important issue, the issue of backlogs in courts. And that's a very important issue because it relates to the core function of the courts. When people have got cases in courts, those cases must be dealt with as expeditiously as possible. They shouldn't be dragging on for a long time. And it is an area in which I hope to make some contribution during my term of office as Chief Justice, namely improving the efficient operations of courts. And in this regard, I want to emphasize that the PEECs, I talked about them in the interviews, those are the Provincial Efficiency Enhancing Committees, which you find in all the provinces. They were established under the leadership of the previous Chief Justice, and they are the people who attend those PECs, who are part of those PECs, are representatives of all stakeholders. You know, the Judiciary, the police, Department of Public Works, Correctional Services, the NPA, everybody that has something to do with justice. And the idea was to say these committees should be able to identify things that cause inefficiencies in the court system, things that cause delays in the system, and jointly seek to find answers to say, how do we make sure that the courts operate properly? So we do have backlogs. That is true. That would have been that was dealt with in the Judiciary annual report of last year, which I presented to the public. But we are working hard to try and improve the situation. But part of the problem would be the number of judges that a particular court has. There are a number of courts where there is a need for more judges, for more posts to be created. You find that all the posts are filled, but there is a need for more posts because the workload has increased, but the number of judges has not increased. So you are bound to have some challenges there. But we are working on those things.
I think the court that you, yes, you had everything judiciary now, but the court that you've been part of its leadership, this one, Concord, is also guilty of that.
No, I agree. We have been criticized, and we accept the criticism that there have been delays in the finalization of matters in the highest court in the land. We accept that. And we are working on that. You know, it's important to first accept that there is a problem, and then to work on a solution. We are working on that. And the delays really relate to how quickly we dispose of applications for leave to appeal, as well as reserved judgments. So we are working on that. Since the last time this issue was raised, there is a lot of progress in relation to disposing of applications for leave to appeal, because we as judges in the Constitutional Court came together and discussed what we can do, and we came up with a way that addresses that.
Fortunately, now, as we're speaking to you as the Chief Justice, are you able to perhaps give us, I wouldn't say a time frame, but an indication of when this problem is likely to be solved?
Well, I can't give you an exact time frame. But the one about applications, I've already indicated that we are seeing a difference already because of what we have decided to implement in how we handle applications for leave to appeal. When it comes to delays in handing down judgments, we are also discussing that. Actually, as recently as last week, we are discussing ways of dealing with that. I'm not going to give you a time frame, but I can assure the public that it is a matter that is very high on our agenda, and I think that it's not going to take long before we see some improvement. But having said that, I must just emphasize part of the cause is. A lot of people know that initially the Constitutional Court was meant to deal with only constitutional cases, but its jurisdiction was expanded in 2013. But when its jurisdiction was expanded, the number of judges was not increased. It's still the same number of judges who must deal with a bigger load. So there is that issue, but we are not saying just because there is that problem, we are not going to do anything. We want to try and see how we can sort it out.
There is another issue, Chief Justice, around our judiciary. There's a lot of talk, real or unreal, perceived or not, that the judiciary is captured. Have you heard of that?
I have.
Are you captured?
Anybody who's captured doesn't behave the way I do.
So basically, people are using this perhaps because of certain concerns in a number of areas, and then they end up saying the judiciary is captured. In fact, let me use a quick example. We saw an exchange of a note from a journalist or a former journalist, or someone writing to a member of parliament, talking about the issues relating to the Constitutional Court. Clearly, I don't think that then helps in terms of this perception. Before I get into that question, I would first ask it this way. Is there a decision around the issue of Public Protector Mkhwebane that is pending imminently?
Well, the matter is pending before the Constitutional Court. The Constitutional Court will announce its decision when it is ready.
Has that decision been taken?
The Constitutional Court will announce when the decision has been taken.
So, the decision is not taken.
The Constitutional Court hasn't announced a decision, therefore there is no decision that has been taken.
But what do you make of that which I've just said in terms of someone texting saying, I have it on good authority that the court will decline the rescission application? I know you may not have been privy to this, but it's out there in public and people are speaking about it.
Well, of course, one can't control what one person communicates to somebody else. This came to my attention, and I've decided that it should be investigated. It is being investigated, and once there is finality, we will let the public know. But certainly, it's something that is very concerning. And well, I said to you earlier on, the Constitutional Court hasn't taken a decision. I must just say, I said to you earlier on that for most of the time I was in meetings. If it has taken a decision in my absence, that might have. But certainly, as far as I'm aware, it hasn't taken a decision. If it has taken any decision, it would have been during the time that I've been in meetings. So I just thought I must just explain that. But certainly, it's completely unacceptable for anybody to say to anybody a court has made any decision that the court hasn't announced. It's completely unacceptable. But I want to stop there because the matter is being investigated.
And I think this fits again into a number of narratives, perhaps, out there. Some people feel the courts tend to involve themselves too much into politics, and then they call it judicial overreach, I think, yes. I think that's the term. So do you feel sometimes as courts, you tend to go a bit more than you should?
Well, judicial overreach is usually used where a court, in making a decision, giving a judgment, is seen to have encroached on the terrain of Parliament or the executive. Now, if you look at the judgments of the Constitutional Court, for example, I just take the Constitutional Court, over many years, you will see that in very many judgments, the Constitutional Court reminds itself of the need not to encroach upon the terrain of the Parliament or the executive. But there are situations which are allowed by our Constitution for the court to get involved in. So to the extent that the court sometimes might make certain decisions that some people might see as encroaching upon the terrain of the executive of Parliament, they need to ask whether those situations are not some of those where the Constitution allows the court to do that. But certainly the Constitutional Court, and I think all the courts, the superior courts, they are very alive to that and do not normally do it. Because before they do anything like encroaching, they ask themselves, do we have the power to do this? And if they believe that the Constitution gives them the power, then they'll do it.
Another issue that has been raised, I think, in public again, is the concern again on the quality of judgments. So what's your view on the general judgments that are being issued by courts?
Well, I think generally speaking, judgments that are issued by courts in South Africa are good, are reasonable. Particularly, I can talk about judgments of the superior courts, which are reported. They are very good judgments. Of course, you will find that sometimes there are some judgments which could have been done better, or which could have which might fall short of the standard in terms of quality that is expected. But I think overall, the judgments that are issued by the courts are reasonable, are of good quality. Yes, we must continue to try and improve. And it's important when one talks about the quality of judgments to also bear in mind that, judges have got to strike a balance between writing this beautiful judgment of very high quality, which might take long to finish, and therefore delay the outcome of the matter, and the need for the judge to hand down their judgment expeditiously. So you have got to strike a balance, because if you are going to give that high quality of a judgment, but you have delayed the finalization of a matter for a long time, people are going to complain. So you have got to strike a balance and look for something that is reasonable. Don't delay unduly in handing down the judgment, but also at the same time make sure that the judgment you hand down is a judgment that will be understood by people who read it.
Let's draw you another cap that you normally wear, and I think the cap that you most famous for, being the chairperson of the State Capture Commission.
Yes.
It was supposed to have been concluded in 6 months, that is 2018. Before it started, you went to court because you realized that the work was going to be enormous. I think you sought, 12 months?
Yeah, at that time, 12 or 18, yes, I can't remember.
That was in 2018.
Yeah.
We're in 2022. As recently as yesterday, you went out to seek another extension. I'm just going to ask a very simple question. Don't you think, Chief Justice, it's better to seek a longer extension so that you just have enough time and conclude all of this? Because if you keep doing these smaller extensions, so to speak, it might affect the credibility of your work.
No, Mr. Mbeje, I think that it would be better to do it that way. But we haven't done it that way. But that's not because we chose to ask for less time when we knew we needed more time. I think maybe I'm to blame here. my assessment has not been as good as it should have been in terms of how much time we need. So I take responsibility for that. But maybe on another level, it's been because I want to finish as soon as possible. It's been 4 grueling years of the commission work, but we are at the tail end of it now. I was looking at the volumes of the report just before we came here, because yesterday morning, maybe about 3 o'clock or thereabout, my staff and I, 3 o'clock in the morning, my staff and I completed part 4 of the report. We were still working at that time. We completed part 4. And it was then electronically sent to the presidency. So it's with the presidency. Arrangements are being made for the day when the Secretary of the Commission will hand over hard copies to the Director General in the presidency. So that is how high the volumes are. Now, that's simply because the Commission had a lot of evidence on very important issues. And we have taken the view that we need to be thorough in terms of the analysis of evidence, because the findings we make affect people. They affect people's reputations and so on. And nobody must find that findings have been made against them, but they don't understand how we arrived at those findings. It needs to be quite clear how we came to those findings. And so we have taken the trouble to try and make sure that the evidence is analyzed properly and thoroughly. But to go back to your question, we are at the tail end. But I agree, it would have been easier to just ask for a long extension. But maybe the unintended advantage of the extensions we ask for is that they put pressure on us to try and finish.
Yeah. Now that we are at the tail end, as you say, when do you think we should be concluded by? I know you've blamed yourself in terms of your judgment, but given that we are at the tail end, so what day, not necessarily date, but what time frame can you then give to say, you know what, by this time I'll be done?
Well, put it this way, I can simply say we have asked for 6 weeks. We are going to work very hard. We think we should finish with that within that 6 weeks. We accept, and I accept, that sometimes the assessment has not been accurate, but we are working very hard. I've just mentioned to you that part 4 of the report we completed at 3 o'clock. We work very hard. We work weekends. We work public holidays. I have a wonderful staff, team of people, also in the legal team, the investigation team, people who can work right around the clock, because we all want to complete this task. As I've said before, there's no one who wants this finished more than I do. Yes. So
I guess especially as you take on the new responsibility.
Yes.
But perhaps still on the issues around the state capture. There is an issue that is out there in public. It caused a lot of situation in the country, that of jailing of former president. Obviously, we know it was as a result of the contempt of court and stuff like that. But some people, Chief Justice, have been saying, why did the Chief Justice go straight to the highest court where he serves, instead of allowing it to go to lower courts and get ventilated there?
Well, you know, I get surprised when some of the people who raise those issues are lawyers, because they ought to know. But also in the court papers that were filed in the Constitutional Court, there was, we dealt with that clearly. We had to tell the Constitutional Court why we were not going to, for example, the High Court, why we were asking that the court should deal with the matter itself. That was dealt with in the papers. Basically, this is what it was. What we wanted the former president to come and give evidence and answer questions which the commission had for him, and if we were going to go to the High Court, and we won, he could appeal to a full bench or the Supreme Court of Appeal. The time that we had, the time frame of the term of the commission, that would have, at least as we saw it then, that would have defeated the whole purpose, because he would have just continued to appeal. So the idea for us was our legal framework in South Africa allows a party to go straight to the Constitutional Court in a particular matter if there are exceptional circumstances. There is a reason why that was put in. And what we did was to put facts before the Constitutional Court to say, these are the reasons why we take the view that it's justified to go straight to the Constitutional Court this time. And obviously, the Constitutional Court, accepted those. Yeah.
So I understand, as you are explaining, Chief Justice, but don't you think perhaps to a layman or a layperson, it would appear that the chairperson, who was the Deputy Chief Justice serving at the highest court, was using I don't know whether proximity is proper, to then go direct, especially because it will then mean the former president will now be denied some of his rights, even that of appealing through the process, because it's still enshrined in the Constitution that he can still appeal. So was it not a way of a shortcut to deny him those rights, because that's how some people are feeling?
Well, again, we have to come back to the point I made earlier, namely that in the wisdom of the drafters of the Constitution, and remember, this is the Constitution that was passed by Parliament. Actually, he was part of Parliament, which passed. I suspect he was part of it, which passed it. Maybe he wasn't. Maybe he was in the province. But I've no doubt that he went along with the ruling party in supporting that the Constitution be passed. So our Constitution recognized that there may well be exceptional cases where it should be allowed that you will go to the highest court in the land, your case will be heard by 11 judges, but you won't have an appeal. It's not just him. There are other matters which have come before the Constitutional Court which have gone direct. Those litigants who are affected don't have an appeal. But that's because it's a system that is allowed by our Constitution. It is not something that the Constitutional Court allows easily. It has got to satisfy itself that there are good reasons. And when it believes that there are good reasons, it allows. Yes, if that happens, you won't have an appeal. But he didn't want to place his case before the Constitutional Court. He had an option to do so. He could have gone to the Constitutional Court and taken exactly that point and say to the Constitutional Court, don't entertain this matter, because I will be denied a right of appeal, and the commission must go to the High Court. And but we know that he did not.
Well, maybe I know that I started my line of questioning around the JSC. I think there's something maybe I forgot, which I think I may need to raise again. How much of a headache is the issue of the Judge President of the Western Cape to you now as chairperson? Because that issue remains unresolved and it's still linked to the Constitutional Court. You are the chairperson now. I think whatever happens, so you have to deal with those issues. How much of a headache? I mean, this is a senior judge, and there are these issues that remain unresolved.
Well, Well, the issues have been resolved in a certain way, in the sense that there is a decision of a tribunal. That decision has been taken on review, but it's different from what was the position for many years. When people said these issues remain unresolved, it's because there had been no decision. You know, a decision has been taken, and it's been taken on review. So it's not a headache, but I am concerned about the length of time it took to get to a decision. It is something that I'm concerned about, not in relation to just his matter, but speaking generally, where cases get delayed and don't get finalized over many years. So we have got to apply our minds to the question of what do we do to make sure that cases don't take as long as this without infringing the rights of individuals to appeal and so on. I know that the heads of court, a few years ago, were also concerned about this issue, and they made a resolution to say the heads of courts should keep an eye on certain matters so as to be proactive and try and have them expedited if delays in how they are resolved could affect certain institutions in a very bad way. So it's something that I'm concerned about, as I say, not just about his matter, about other matters that one becomes aware of, because when matters get dragged for so long, for years, people will begin to say, is the justice system working? Why is this not being finalized? So we need to find a way of striking a balance between cutting down on the delays without, however, taking away the rights of any litigant to appeal if they have a right to appeal.
There's another issue around the code of conduct relating to the judges, which I think if I just try to dust up whatever is written, I think it must be reviewed, I think, within every 3 years. Yes. And that doesn't appear to have happened. And I think issues relating to the former Chief Justice, I think he was subjected to this with this old codes of conduct. So when are you going to take this thing up and review them?
Well, interestingly, I think a few weeks ago I was looking at exactly that, there may be a need to have a look at it. It might not mean that anything will change, but certainly I think what is expected is that within certain intervals, and I think you might be right, maybe it's 3 years, within certain intervals, we should look at it and see whether it needs any amendment or not.
Yes.
So it's something that I will be looking at in due course.
I'm not sure if it's giving you a bit of an option if it says you must.
Well,
and I think maybe was out of the way.
Well, I can't remember the actual wording, but I do know that certainly it's supposed to be reviewed within a certain period of time, and so if it says must, and that period has come and gone without it being reviewed, we obviously will have to do what we can, even if it's after. But obviously, if that period has not lapsed, then we must comply.
And then there are also, I think, is it a perception, is it a suggestion, or is it a talk, that the judiciary, particularly around you, is sympathetic to the incumbent. And then people would raise the issue of the ceiling of the CR17 and matters relating to the public protector and stuff like that. So,
Well, you say incumbent, who do you mean?
The president.
Oh, okay.
The president, President Ramaphosa. So basically what I want to know is, what are you doing as the judiciary to make sure that you are seen to be totally independent, not really doing a bidding of anyone? I know it's not that that's what you're doing, but remember, perception matters, even in the courts. I think you say that. You say justice must not be done only, it must also be seen to be done. That's perception. So what are you doing as the judiciary to make sure that this is done?
Well, the best thing we can do is do our job the way we are supposed to do it, which is in accordance with our oath of office. The next thing we can do is to make sure that the way we conduct ourselves is such that it should not give anybody reasonable grounds to have those perceptions. But having said that, I suspect that sometimes some people accuse the judiciary in general, or certain judges, individual judges, of bias or of favoring certain groups or individuals, but not because they've got facts to back that up with, but because they want the judges or the judge to be concerned next time he or she must make a decision, to say something like, hey, so far I've been finding in favor of so and so, I should find in favor of the same party. But if I find in favor of that party now, this perception that I'm biased is going to be strengthened. So I must try and find for the other party. But that would be wrong. That would be wrong. The judiciary should never do that. The judiciary must do its job in accordance with their oath of office. If you are entitled to win in terms of the law and the evidence 5 times in front of me, you must win 5 times. I must never deny you a victory in a case because I'm trying to protect myself that somebody is going to unfairly say I am biased in your favor. Our guiding principle is our oath of office. We've got to do our job without fear, without favor, without prejudice. So if people make all kinds of unfair accusations that, a particular judge, whether it's me or another one, is biased in favor of a particular politician when they've got no facts to back that up with, I will decide my cases in accordance with my oath of office. And if the same person must win, they will win. If they must win again, they will win. And anyone who has got evidence that a judge is captured or a judge is biased, the structures are there. We tell the public all the time. We've got the Judicial Conduct Committee. The public knows that that conduct committee is working. It has made findings against judges. They must take their complaints there, but they don't take them there because they know they don't have evidence. But they keep on saying these things in the public, and I think the public needs to look at these accusations against the judiciary, in a way that shows that we as the public disapprove of people who make all kinds of accusations against judges without facts.
Are you worried, Chief Justice, about some of the attacks, be it political, on the judiciary, or do you equate them to criticism? We saw you respond to a letter which was written by the minister, at some point. Is it being intolerant to criticism, or is it being worried by attacks? In a minute, Chief Justice, so we're running out of time.
Yeah. Well, one, we have always said we accept that we can be criticized as the judiciary, and we won't be responding to every criticism, but we will draw a line. There are instances where we will respond, but there are many instances, even as we speak, where we have been criticized and we don't respond because we think it's fine, it's just criticism.
So you would take it in your strides where it's criticism?
We'll normally we won't respond.
Yeah.
It's only in exceptional circumstances where we will respond.
Are you worried about political attacks, perhaps?
Well, I'm very concerned. I think that when I look at the future, it's very likely that the judiciary is going to be attacked more and more. I think it's going to happen, but we are going to handle it the way we think it should be handled. As I say, some of it we'll let go, but we will draw a line somewhere.
Well, thank you very much, Chief Justice. I know it feels like 10 minutes because there are so many issues, but of course it's taken so much. Thank you very much for your time. We know it wasn't easy, but we're glad you were able to make the time for us.
Thank you very much. I think it was a good thing that I made time. I think the public needed this. Thank you very much.
I know the judges speak through their judgments, but I think time and again, because of your role, you will let us in.
No, yeah, I will. From time to time, I will.
Thank you very much.
Thank you very much.
Well, that was the newly appointed Chief Justice. He's actually 28 days in office. He was appointed by President Ramaphosa, remember, after those interviews. So we've had an interesting interview with him. But of course, as he has promised time and again, he will grant us those interviews just to give us the picture of what is happening in the judiciary and in the country in general. Let me take this opportunity to link you back to the studio, to the ad break.